Welcome to Ask the Expert with noted radio host Steve Sleeper. Each week, Steve interviews entrepreneurs and professionals and shares their intriguing stories of success and service. Now, here's radio veteran Steve Sleeper.
And welcome to another edition of Ask the Expert. Today, our guest is mediation attorney Jay Lazrus with the Ray Group in the Washington, D.C. area. Jay, how are you today?
I'm doing fine. How about yourself?
I'm good. Hey, tell me a little bit about yourself and your firm, Jay.
Okay. Well, basically, I provide mediation and arbitration services under the business name the Ray Group. I've been a practicing attorney representing small businesses and individuals since 1981. Several years ago, after years of frustration with the legal system, I undertook training as a mediator. Now I use my skills and experience as a mediator to help parties try to resolve disputes in a confidential manner that saves time and resources and preserves relationships.
Okay, so what is, it's kind of a twofold question, I guess threefold question. What is mediation, what is arbitration, and what's the difference between the two?
Okay, I think that's a good question, Steve. In arbitration, the arbitrator listens to the evidence and documents that are presented to the parties and renders a decision based on the arbitrator's review of that information and also relevant law. You can think of an arbitrator as a private judge. In mediation, on the other hand, the mediator assists the parties by engaging in a conversation with them about the dispute. The mediator helps each side understand the evidence and the point of view of the other side, helps them to develop options to resolve the dispute, and often helps the parties develop a framework for future conversation and interaction without the help of the mediator.
I see.
Basically, unlike in arbitration, a mediator will not impose a decision on the parties. That's the principal difference. In arbitration, the arbitrator decides. In mediation, the parties decide.
I see. Okay, now what kind of cases can be mediated?
In my view, I think any dispute can be mediated as long as the parties are willing to look at the dispute objectively and are open to a compromise. In my career, I've mediated many types of matters: business disputes, partnership squabbles, creditor-debtor issues, landlord-tenant condo association matters, will contests, divorce and custody. These are just a few of the disputes that I've handled.
And how long does mediation take typically?
Well, that depends on a variety of factors. The principal ones being the nature of the dispute, the number of issues that need to be resolved, and the amount in controversy, as well as the personalities of the parties. For example, a typical mediation session lasts 2 to 3 hours, and many matters resolve themselves in 2 to 3 sessions. However, I've had mediations end as quickly as 20 minutes into the first session, and others involve many sessions over a period of months. Basically, each problem is unique, and therefore each mediation is unique.
Okay, now how can I be sure that mediation is going to produce a fair result, Jay?
Well, I think the way I look at it, if you start out defining fairness as an outcome that's right or acceptable, then fairness basically is baked into the mediation process. Because in mediation, both parties have to agree to the result, or an impasse is reached and there's no resolution. So I think almost by definition, mediation produces a fair result if it results in a settlement.
Now, are there stages to mediation?
That's an interesting question. I think you can probably take each mediation and divide it into 2 stages if you wanted to. I think in the beginning, you have the input and the information gathering stage, where each side presents their view of the case, what they think the resolution should be, why they think the resolution that they suggested is the appropriate one in this matter. After that's been done, the conversation turns to a give and take between the parties, analyzing the positions and evidence that each side has presented. And the mediator is guiding this dialogue all along, trying to clarify the issues and pointing out where the parties may agree, even if they don't realize they're in agreement. At some point, you reach a different stage where the conversation turns to considerations of possible resolution of the issues. At this point, the mediator helps the parties to brainstorm options, analyze the pros and cons of each option from each party's point of view. At this point in the resolution process, if you've gotten this far, typically a resolution that's acceptable to both parties will emerge, and then you reach the final stage where the mediator drafts a memorandum that outlines and describes the understanding that the parties have reached.
Okay. How, and this is going to be a twofold question, how do folks typically find you, and how do you find a good mediator? Okay,
well, as far as finding me is concerned, I'm on the web, as almost everybody is these days, at www.raegroup.com. I also have my bio and advertise on a number of mediation sites as well. The question of finding a good mediator is an interesting one. I think a good mediator is basically can be a different person depending on the who the party is, because the selection of the mediator depends on the party's background and also the nature of their dispute. I think that someone who's looking for a mediator should do some investigation, should investigate the mediator's background, the mediator's training, and the mediator's style. Mediators come from many walks of life, including law, social work, and therapy. Some mediators have no formal training, others have coursework and general mediation skills, and some even have specialized mediation training. There are mediators that use a style that's known as transformative mediation. That's where a mediator focuses on transforming the dialogue with the parties from negative dialogue to positive dialogue. Others practice facilitative mediation, in which the mediator's focus is on helping the parties reach a mutually acceptable result. Still others practice what's known as analytical mediation, in which the mediator attempts to adjust the process to suit what the mediator perceives of the needs of the parties. In my practice, I sort of sway from the facilitative mediation to analytical mediation. I do try to focus on the needs of the parties and develop the framework for mediation that will best help them reach the result that they're looking for.
Okay, so I think this leads into my next question really well, Jay. Are there some cases that should not be mediated?
Well, as I said earlier, I think almost any dispute can be mediated. There are probably, however, a caveat that there are probably a couple types of mediation cases that should not be mediated. The first is basically when the parties are 100% convinced that their side is right, and therefore they're unwilling to compromise at all.
Yeah.
However, in my experience, I found that even in those situations, that's because the parties are not looking at the situation objectively, and if they did that, they would realize that maybe they're not 100% right, and maybe this case can be mediated. So even in those cases, I think you need to look very carefully, and maybe mediation is appropriate. However, the situation where mediation is probably never appropriate is when a party is trying to achieve a change in a law or see a principle upheld. In those cases, litigation is almost invariably necessary. An example of this type of matter is if someone was accused of libel and needed a public vindication in order to be satisfied. In that case, they would probably have to take the matter to a trial and be vindicated in a court of law.
Okay. Now, if I choose mediation, do I still need a lawyer?
Well, I think that depends. In complex cases, an attorney will almost always be needed to make sure that all the T's are crossed and the I's dotted. On the other hand, take the other extreme, in very simple cases, the cost of an attorney may be prohibitive and even render a resolution impractical to the parties because of the cost of the attorney. In between those two extremes, the need for an attorney will depend on the amount at issue, the complexity of the issues, the sophistication of the parties, just to name a few factors. In the cases that I've mediated, I would say it's about 50-50 in terms of the times when the parties hire an attorney.
Okay. Now that's good information to know. And our guest today on Ask the Expert has been Jay Lazrus with the Ray Group, Silver Spring, Maryland, which is the Washington, D.C. area. If you're ever in need of mediation service, and I think Jay's done a really good job of outlining when it's needed, give Jay a call. Jay, what's your phone number?
My phone number is 301-384-9579. And I might also add that I do offer free initial 30-minute consultations to discuss the matter and also to discuss the mediation process if anyone's interested.
Oh, that's great. That's great. And your website is theRayGroup.com. That's RAE Group.com. And Jay, thanks for being on Ask the Expert today.
Well, thanks for having me.
Thanks for listening to Ask the Expert with Steve Sleeper. Join us next time as entrepreneurs and professionals share their intriguing stories of success and service.